know. What are these pointers? Number one, now before we start, welcome to the Magna Carta Prelims 2024. This is lecture number 6, which is legislatures. Now, before we start with legislatures, there are a few very important pointers that we must know. What are these pointers? Number one, when we look at the prelims exam, there are a few very important indicators that come to mind. First things first, under no circumstances have any article numbers been asked. 2, questions from here have genuinely been very consistent, but despite the fact they have been very, very basic, and over the last 5 years, they have been very procedural in nature. Having used the word procedural, a lot of technical procedure which is in the rules of procedure of the houses is not actually asked. What is asked are procedures with respect to the Constitution of India. So that is something we have to keep in mind. So how do we study legislatures? We first study them on a comparative basis. This means we will look at all the union and state legislatures together. That's the key point. 2, we will then do it section by section. We'll first pick up the houses, then we'll pick up the presiding officers, then we'll pick up the members, then we'll pick up the procedures, then we'll pick up passage, and then we'll pick up parliamentary committees. And they have to be done with a very, very specific restraint in mind. Yes, there are questions that are asked in the prelims exam, but the questions that are asked in the prelims exam are questions which are very, very basic. These questions are not complicated by any stretch of imagination. So let us begin with a comparative review of the houses. Now, if there's one thing that we have to remember at all times, it is this. India is a parliamentary democracy. And the fact that India is a parliamentary democracy would effectively mean two things. One, the Council of Ministers are collectively responsible to the lower house. This will give us a lot of practical insights. This will teach us as to why restrictive motions are only in the lower house. This will teach us how a specific nature of a specific committee will decide whether it is only a Lok Sabha committee or not. At the very same time, it will also tell us that different kind of bills would have a different house priority, which means embedded in Council of Ministers collectively responsible to the lower house is actually rule number 2, which is center stronger than the states. And thirdly, as an application of this, you will also see separation of powers and checks and balances applied at multiple places when we are studying legislatures. So without any further delay, let us begin. This is effectively the layout of the legislatures of India. Now, as far as the parliament is concerned, Article 79 tells us that the parliament comprises of the president, the Lok Sabha, and the Rajya Sabha. And the state legislatures comprise of the governor, the legislative assembly, and legislative councils wherever applicable. So the first key question is, why is the president a part of the parliament? Now we will see this logic to be applicable in various subsequent sections. The president tends to be a part of the parliament, certainly not a member of the parliament. Now, what does this mean? When the president is a part of the parliament, it is signifying something very important. That is, whenever the parliament makes a law, it is a law which is nationally applicable. and the nation comprises of the states and union territories. So therefore, when the parliament is making a law, the parliament is making a law which is applicable to all states and union territories under ordinary circumstances, which means, by definition, the fact that we have a union parliament means that there is some amount of a federal setup in the country. So if the parliament is going to be making laws which are applicable to the entire country, that means it is going to be applicable to the states. And therefore, to keep a check on whether the law is actually a good law or not. Because what generally happens is the Lok Sabha represents the popular mandate of the people. And the party in majority at the Lok Sabha has to necessarily ensure that they continuously enjoy the confidence and the majority of the country as a whole. So they will do whatever it takes to come up with nationalist, populist policies. Whereas the Rajya Sabha is a representative of the states. So they will always have state interest in mind. So on the one hand, you have populist interest, and on the other hand, you have state interest. And somewhere we have to make sure what is actually national interest. So this is why the president is made to be a part of the parliament. Of course, as I said before, the president is not a member of the parliament. Now, because of the fact that the president has been elected by both the members of the center and the state legislatures, gives the president the legitimacy to ensure that the bills are passed righteously. And secondly, the president by law, as per the constitution, is an apolitical office, which means the president is not bound by the whims or the fancies or the aspirations of any political party whatsoever. So, which is why the president being a part of the parliament makes a substantial amount of sense in keeping the integrity of the parliament alive. So therefore, let us now quickly look at the general overview. So the Parliament of India is a bicameral parliament, which means we're going to have two houses. This bicameralism has two very major implications. First, it helps you uphold the rule of law, which in turn helps you to uphold principles of constitutionalism. Because by the sheer fact that you have the Lok Sabha and the Rajya Sabha, which means under ordinary legislative provisions, they have equal powers. So they will keep a check on each other's mandate. And two, it also helps you balance the unitary federal setup in the country. So bicameralism has two significant roles to play. One, to eventually uphold constitutionalism, and two, to also balance the nature of the federal polity of the country. Now, as far as the organization is concerned, the Lok Sabha and the Rajya Sabha are your two houses. They will comprise of presiding officers on either ends. The presiding officers of the Lok Sabha and the Rajya Sabha are two completely differently placed officers. Now, the presiding officers of the Lok Sabha are the Speaker and the Deputy Speaker. Both of them are members of the House. Just in case both of them are not available, you also have a backup panel of chairpersons. A House is nothing without its members. So you will have a bunch of members. These members are going to be elected only because after the constitutional amendment in 2019, the 104th amendment, we have removed nominations to the Lok Sabha, which was on the grounds of Anglo-Indians. So you now only have elected members. Now these elected members would come from a majority party, would come from the opposition, would also be independent members who have won an election without any political party sponsoring their ticket. Now, this is the primary composition of the Lok Sabha. The Lok Sabha is supported administratively by the Lok Sabha Secretariat. The Lok Sabha Secretariat is headed by the Secretary General of the Lok Sabha. The Secretary General of the Lok Sabha, in fact, is one of the highest ranking civil servants in the country and is equivalent to the rank of a cabinet secretary. However, given the nature of the work of the Lok Sabha, the Secretary General is not a very public facing office. The Secretary General works behind the curtains because you're already a part of a very public house called the Lok Sabha. Similarly, you have the Rajya Sabha. Now, there is something unique about the Rajya Sabha. What is unique is that the chairperson of the Rajya Sabha is the Vice President of India. We use the term ex officio. This means whoever is the Vice President is the chairperson of the Rajya Sabha. The reverse is not true. Whoever is the chairperson of the Rajya Sabha is the Vice President is not true. So what is actually true is the Vice President of India is the ex officio chairperson of the Rajya Sabha. The question therefore becomes why? See, the Rajya Sabha is a representative of the federal will. We will discuss in detail, but the Rajya Sabha is elected by elected MLAs at the state legislative assemblies. Now, if you're choosing somebody to preside over them, and in the first instance, you're choosing somebody from the House, that would effectively mean states which have a larger seat share or have a common political party will therefore have an upper edge in choosing the presiding officer. And that will go against the intent of creating a second chamber in the first place. And therefore, the Rajya Sabha is supposed to anyways be a representative of the federal will. Now, if you think about it, like the president, the vice president is also not a member of parliament, but is a part of the Rajya Sabha. Constitutionally, the parliament comprises of the Lok Sabha, the Rajya Sabha, and the president. But when you look at it in detail, even the vice president is a part of the Rajya Sabha. Now, what happens is, because the primary function of the vice president is to preside over the Rajya Sabha, so when you're effectively choosing the vice president, you are choosing the vice president who's also the chairperson of the Rajya Sabha. So when you are electing or removing the vice president, you're also electing or removing the chairperson of the Rajya Sabha and vice versa. And there was literally no one else left. The president is anyways a part of the larger parliament. Nobody from the executive or the judiciary can step in because of separation of powers. So the only person who's left in any manner happens to be the vice president. In fact, it is argued that the primary purpose of creating the vice president's office was to ensure that the Rajya Sabha has someone to preside over. And of course, when the vice president is officiating as the president, then the vice president is not performing the presidential functions of presiding over the Rajya Sabha. Then the deputy chairperson is a member of the Rajya Sabha who's chosen from amongst the Rajya Sabha members. Like the Lok Sabha, you're also supported by a backup panel. And the Rajya Sabha has members. Now, the Rajya Sabha members are nominated and elected. What the criteria for nomination is, we will discuss in just some time. But unlike the Lok Sabha, the Rajya Sabha has elected and nominated members both. Now, at the end of the day, we are looking at the institution of the parliament. And because we're looking at the institution of the parliament, what really becomes important is the notion of parliamentary committees. So you will have multiple types and formats of it. You will have standing committees who are reconstituted on a frequent basis. You will have ad hoc committees which are set up for a specific purpose. You will have committees of members only of the Lok Sabha or the Rajya Sabha or both. These are called select committees or joint committees respectively. And the Rajya Sabha, like the Lok Sabha, is also supported by a Secretary General and the Rajya Sabha Secretariat. The idea is the exact same ecosystem is replicated at the state legislatures. So generally, when we refer to state legislatures, Article 168 very categorically says that the state legislatures will comprise of the Legislative Assembly and the governor. Now, the same reasons as to why the president is a part of the parliament is the same reason as to why the governor is a part of the Legislative Assembly. The governor is a part of the Legislative Assembly singularly to maintain a sort of impartiality. And it also is a very tiny application of rule number 2, center stronger than the states, because the governor is effectively appointed and removed by the president who works on the advice of the Council of Ministers. So similarly, you have the Legislative Assembly and the Legislative Councils. The primary difference is that the Legislative Councils, their presiding officers, both of them are members of the House. They have similar members. They also have nominated members with an additional criteria. They also have secretaries, secretary generals, and secretarials. They also have committees. And also, 2 union territories have functioning legislative assemblies, Delhi and Pondicherry, while the J&K Union Territory is supposed to have a legislative assembly in time to come. Legislative councils are only in a select few states. Now, the Constitution mentions the states in which you're supposed to have legislative councils. Bihar, UP, Karnataka, Andhra Pradesh, and Telangana all have functioning state legislative councils, whereas the state of Tamil Nadu has all the legal provisions done to have a legislative council. But having said that, it does not have a functioning legislative council. Now, very interestingly, this entire ecosystem is governed with 3 basic pillars. 1 is the Constitution, 2 are rules of procedure, and 3 are conventions. Though the prelims exam has rarely asked what is what, but something which is very definite and has a larger regulatory value will be in the Constitution. Something which is very internal and closer to separation of powers will be in the rules of procedure. And something which cannot be categorically defined would generally be a convention. So this is an easy way to know what is what, though the prelims exam of late has not asked you which is what. But this is largely the layout and the structure of legislatures in India. Now, let us look at exactly how they function. We start with a comparative review. Very clearly, we will do it on these parameters, and these parameters are more than enough. We will compare the Lok Sabha and the assemblies together, and we will compare the Rajya Sabha and the state legislative councils together, because both of them are collectively lower houses and both of these are collectively upper houses. Now, let's start with the tenure. The tenure for the lower houses, both at the center and the states, is 5 years. And their tenure ordinarily can be ended through a dissolution. This dissolution is automatic after 5 years, or if after a no confidence has been passed, the House still does not have, or the majority does not have the confidence of the government, or the government does not have the confidence of the majority. But with legislative assemblies, apart from dissolution and no confidence, you have Article 356, under which the legislative assembly may be dissolved. It is not always the case. It could sometimes be the case. Now, when we look at representation, the Lok Sabha will represent all states and union territories in India, no matter what. It does not matter how big, how small, how diverse you are, because you are talking about the national house. You're talking about the democratically elected lower house. All states and union territories will be a part of the Lok Sabha. However, the Legislative Assembly will represent the territories within the state. The election format for both of them is also the same, which is these are direct elections and these are based on first past the post system. First past the post system simply means you need to get more share of votes than the others. This means, for example, there are four candidates, A, B, C, and D. Let's say a total of 10 votes have been cast. A gets 4, B gets 3, C gets 2, D gets 1. You get a total of 10 votes. As per first past the post system, what is basically the case is A will be declared the winner because A has more votes than everybody else. And because A has more votes than everybody else, A has crossed the post the first. Hence, first past the post system. Of course, it is indicative that 60% still do not want A, but 40% singularly want A. So that is good enough as a reason to declare A as the winner. Now, having said that, there are certain basic principles of lower house elections. The basic principles of lower house elections are, and these are very simple ones. These are, first, ultimately, you are going to draw up constituencies. These constituencies are basically territorial boundaries. You would try to ensure that the number of people that are residing in a constituency are roughly the same. So you will draw your constituencies in a way that a similar number of people are within a constituency. Now, the Election Commission gives you a plus minus 15% margin, and that is okay. But the idea is you are trying to create a constituency which approximately has the same number of people. It is the same thing as saying if a coaching institute has to have 10 batches, so you will roughly have the same number of children in each batch with minor fluctuations here or there. This is only fair. So this is the first principle. The second principle is that the ratio of the number of seats to population should be uniform. So for example, if a state has 10 people and has one seat, the ratio becomes 1:10. And this ratio should be uniform across the country, which is why you will generally see in the Lok Sabha, states with higher population will have a larger number of Lok Sabha seats allocated to them. This could also be true for legislative assemblies, but in legislative assemblies, you will see a combination of population and geography, which play an inter role in determining the number of seats. Anyway, so this is the election format. Now, as far as the basic election details are concerned, in both the cases, one person, one vote. You only vote once. And two, if it is a party ticket that you're contesting, then in a given constituency, you will have one party for one constituency with one vote, which basically means that one party is going to give you only one ticket in each constituency. In one constituency, you cannot have two people on a BJP ticket or two people on a Congress ticket fighting. That is not going to be possible under any scenarios. So this is what is called the election details. Now, of course, the population that we use is the 1971 census to determine most things. We use the 1971 population basis is to effectively promote population control measures. If you noticed, the population plays a very large role in the number of seats that are allocated to you. And if that is the case, then More the population, you would ask for more number of seats. And that is not particularly justified. Because that is not particularly justified, what will generally happen is the states who have not been able to control their population will therefore keep on asking for more and more seats. So to balance it, we've kept it for 1971. And this is why the number of seats have been frozen till the year 2026 based on the 1971 census. Now, the number of seats versus the size of the constituency are two very different things. The size of the constituency can be adjusted on a frequent basis depending on migration. And if you actually study migration in India, you will notice that there is a larger tendency of intrastate migration than interstate migration. So basically what happens is, if this is a state and these are your constituencies, if there is a very large migration here because of some development, you will have to decrease the size of the constituency because the density of the population has become higher. And so that you can maintain the larger same number of people under each constituency concept intact. For this, you have an organization called the Delimitation Commission, which is a constitutional body. And the orders of the Delimitation Commission are not subject to judicial review. This is simply because of rule number 3, separation of powers. You are not getting into effectively the conduct of elections or the outcome of it. What you are getting into is effectively nothing but the redrawing of boundaries to ensure that elections are fairly representative in nature. So these are your primary features. In addition to these primary features, you also have certain numbers. Now, what are these numbers? The maximum strength for the Lok Sabha is 550. But based on the population, number of states, union territories, we figured out that we should have a total of 543 constituencies till about 2026. And then we may be changing the base of our census. And when we do decide to change the base of our census, what will happen is the number of constituencies is going to significantly increase, which is also why we've moved into a new parliament. On the other hand, the maximum strength of legislative assemblies is between 60 to 500. Now, this 60 number can also be reduced for smaller states like Sikkim, but the general range is about 60 to 500. Again, dependent on the population, the geographical extent of the state, and also the density of population herewith. So this is largely how Lok Sabhas and legislative assemblies are constructed or structured. When we now look at the upper houses, the Rajya Sabha and the state legislative councils, very interestingly, both of them are permanent houses, which means they are never dissolved. They essentially prove a concept called continuity of the house. This continuity is important because at the end of the day, we are a parliamentary democracy. And for a parliamentary democracy to be functional, a parliamentary house must always be omnipresent, which is why you would have the lower houses as permanent houses. So what generally happens is every 2 years, 1/3 of the members will retire on a rotational basis. The first time we decided to do this was on the basis of a lottery. But generally what happens is the average tenure of a Rajya Sabha or an MLC member is about 6 years. Whereas the average tenure, the ordinary tenure for a lower house member is 5 years. This 6 years also shows that you are 1 year beyond the ordinary time, which means that you are above and beyond political repercussions. Now, As far as Rajya Sabha is concerned, Rajya Sabha is a representative of the states. So for states to have a representation, they need to have a certain amount of population. So therefore, all states are represented to the Rajya Sabha, and two union territories, Delhi and Pondicherry, because they have functioning legislatures, are also represented in the Rajya Sabha. On the other hand, the state legislative councils are representing institutions or entities within the state. And there is, of course, a fairly complex procedure. The idea is Rajya Sabha members are elected by the MLAs of the state and not necessarily from the MLAs of the state. So they are by the MLAs, not necessarily from the MLAs. Can an existing MLA contest a Rajya Sabha election? Of course. But does that necessarily be the case? No. So the format of election to the Rajya Sabha is an indirect election. How is it indirect? It is indirect because the MLAs are choosing members to the Rajya Sabha, right? So that is how it is indirect. Now, having said that, you also have the system of proportional representation, which means that depending on the size of the state, depending on the number of legislative assemblies, depending on the strength of the vote of the legislative assembly member, each state is going to have a different allocation of seats at the Rajya Sabha. And this is also a feature of what is called asymmetric federalism. And Rajya Sabha votes are to be therefore calculated on a proportional basis, where, like the precedent, you will also have a value vote system. The value vote system to the Rajya Sabha is a fairly simple system. It is that an X person's vote will depend on the number of vacancies. So, for example, let us say the state of UP has a total of 10 Rajya Sabha seats. Out of these 10 Rajya Sabha seats, only 5 Rajya Sabha seats are vacant. So elections to these 5 Rajya Sabha seats will happen at the Legislative Assembly of UP, where elected Legislative Assembly members of UP are going to be participating. Now the idea is they will be participating in a very unique manner. So if there are 5 total number, then you will have, let us say, total MLAs into 100 upon vacancies plus 1, and this entire thing has to be added by 1. So let us say the total MLAs of UP are 100. So 100 into 100 plus 5 plus 1 and plus 1. That's the basic concept. To actually simplify it, you can remove the 100 number and it would be 5 upon, let's say, 100 plus 1. Sorry, 100 upon 5 plus 1 plus 1, which means this would be the number of times, this is the number of votes each contestant from the Assembly of UP would have to have. Very simply, what you're trying to calculate is the number of votes required for a contestant to win the Rajya Sabha seat, which is being currently contested. And just about 5-6 days ago, several Rajya Sabha seat elections have been declared. And it has been a matter of political controversy also that, for example, a senior leader, Mrs. Gandhi, would be contesting from a Rajya Sabha seat in what is called Rajasthan. So the basic concept is this. Now, again, these Rajya Sabha MPs are to be elected by the state legislative MLAs. So you simply require a minimum number of votes. I'll do this again with you. For example, let's say UP has 100. So 100 upon has 100 MLAs. Let's say there are 5 vacancies. So 5 plus 1 and plus 1. This is the minimum number of votes that would be required for a person to win that seat from UP to the Rajya Sabha. Okay. Now, this is generally what is called a Rajya Sabha election. And as far as state legislative elections are concerned, council elections are concerned, very interestingly, you have voter qualifications. The electorate that you create is an indirect electorate, but you have voter qualifications in the essence of it all, which means everybody cannot vote in a state legislative council election. So this is generally how it works. The constitution in the fourth schedule very clearly identifies the number of seats that each state will have to the Rajya Sabha, which is why, if you remember, in territory we had discussed that if you're making a change to Schedule 4 for territorial reasons, you would not consider it a constitutional amendment. Now, very interestingly, state legislative councils are not compulsory. That means they can be created at the will of the states. You would remember this in majority. What generally happens is, and this is the procedure about it, the procedure is a fairly simple one. The procedure is the state legislative assembly will first pass a resolution. This resolution has to be passed by more than 2/3 of present time voting. Then this resolution is forwarded to the parliament. Now, the parliament may or may not act upon it. If the parliament decides to act upon it, it will pass an amendment to the constitution, creating a state legislative council. But that amendment will not be considered an amendment under Article 368. This is also a beautiful application of rule number 2, center stronger than the states. Now, why is that the case? That's the case because while the state legislative assemblies initiate the fact that they want to create a council, but the final call on whether the council can be created or not is decided primarily by the parliament. So this is nothing but rule number 2, center stronger than the states. Now, with the Rajya Sabha and Legislative Council, there's also a numbers game. Based on the population and the vote values and everything, the maximum strength is fixed at 250. Our current strength is about 245, out of which we have 233 elected members and 12 nominated members who are nominated by the President on the advice of the Council of Ministers. Because everything that the President does is on the advice of Council of Ministers. Now, literature, arts, science, and social service. Literature, arts, science, and social service is the criteria on the basis of which you can get nominated to the Rajya Sabha. On the other hand, the Legislative Council, like the Assembly, has a range. The range is you can have a minimum 140, minimum 40, and this 40 can also be lesser for smaller states. But the maximum that you can have is 1/3. If you notice carefully, the Rajya Sabha is approximately half the size of the Lok Sabha, whereas the council at the most can be 1/3. This is also an application of rule number 2, center stronger than the states. Now, how are legislative council members elected? Legislative council members are elected in the following manner. 1/3 of them are elected by the MLAs. This is like a mini Rajya Sabha election. 1/3 are elected by local bodies, your Gram Panchayats. Another 1/3 are elected by teachers who have been teaching till the 10th grade for the last 10 years, for the last 3 years. And another 1/3 are elected by graduates who graduated at least 3 years ago. So this becomes your electorate. And that is why I said you have voter qualifications when it comes to electing members of the state legislative councils. Now, like the Rajya Sabha, they would also have nominations. And 1/6 are nominated by the governor on the advice of Council of Ministers. Now, what is this 1/6 on? This 1/6 is on cooperatives, literatures, art, science, and social service. Now, why cooperatives? Because cooperative societies is in the state list. And because cooperative societies is in the state list, what ends up happening is it becomes a nomination criteria for something in the state legislative councils. So that's the basic purpose. That's the basic understanding of how things are done. Now, the elections to all of these are conducted by the Election Commission of India. And if there's a dispute to the outcome of the election, then the dispute has to be filed through an election petition through the High Court. But if you have an issue with the management of elections, then you can take it up with the Election Commission. But election petitions are dealt with by the High Court. Again, in application of rule number 2, it is the ECI, which is centrally a constitutional body, conducting elections to the central institutions and the state institutions. But the disputes with respect to the outcome of elections are largely dealt with respect to the high courts. And while the high courts would think, while the states would think the high courts are our highest judicial organs, but the states have a negligible role to play, either in the appointment of high court judges and nor in the removal of high court judges. But this is generally a comparative review. Now, very interestingly, the final concept is, except for the states, there is a residency requirement in the states, here also and here also. You have no residency requirement whatsoever to contest a Lok Sabha or a Rajya Sabha seat, which means you don't have to be from a specific state or from a specific constituency to contest either of the two. This was not the case with the Rajya Sabha originally, but after the 2004 mandate of UPA 1, they changed it to ensure that our previous Prime Minister, Dr. Manmohan Singh, was able to contest from the Rajya Sabha seat of Assam. But from a comparative review, this is more than enough. You don't need anything else. If there is at all a question, it should be from here. Now, don't worry too much about the formula as far as the Rajya Sabha seats are concerned. What you should generally know is, higher the population, therefore higher the number of seats. Now, higher the population coupled with, say, the geographical extent as well. But that's pretty much it. We don't have to worry too much about it. A comparative review is sorted. Now, we have to look at the positioning of the houses. This is important for the prelims exam because there are questions that have been asked from here. So, ordinarily, and this is the important part, the primary understanding is no law in the parliament can be passed unless it is passed by both the houses. Even if one of the houses is playing a supportive role, even if one of the houses is playing a secondary role, but that does not mean that the bill cannot be passed or should not be passed. Even in something like the budget, the Rajya Sabha will be passing the bills of the budget. Symbolically though, but will be passing the bills of the budget. So what do we generally need to know? The special cases. Anything apart from this is all good. They have equal powers. So places where the Lok Sabha has a higher power than the Rajya Sabha, you will generally see on the legislative front, money bills and the budget, slightly higher powers. Powers of passage. Now, what is the passage power? The Lok Sabha basically overrides the Rajya Sabha when it comes to a money bill. And the budget is a type of a money bill. It's in fact a more aggressive version of the money bill. So what generally happens is, in a money bill, you'll give the Rajya Sabha about 14 days to suggest some kind of, some form of suggestion amendment. The Lok Sabha can either accept those changes or can reject them outrightly. And even if the Rajya Sabha doesn't get back to them within 14 days, the Lok Sabha will carry on, will assume that the Rajya Sabha is on board with it, and so on and so forth. Procedurally, again, this is an application of center stronger than the states. In both of these cases, what you're effectively doing is center stronger than the states. The reason the Lok Sabha gets more powers than the Rajya Sabha in monetary matters is because monetary matters are a true sign of what is called independence, what is called autonomy. And the states would anyways have their own monetary spheres to deal with. There is a state budget, there is a state consolidated fund, and so on and so forth. So we don't have to be worried about it. What we need to be worried about is that as the central house, are we able to run and have autonomy over financial decisions? Because at the end of the day, democratic mandate rule number 1 tells us that the Lok Sabha is the powerhouse of the democratic mandate. And financial resources give the power to the government, the fuel to the government to implement the policies that they want to. So if you want to implement policy X, you will require funds Y. If the Rajya Sabha could have a say in the allocation of those funds Y, it would therefore render the entire autonomy pretty useless. Now, similarly, you have something called procedural superiority. Again, anything which is raising a question mark on, say, the confidence or the hold of the majority party, it has to be within the Lok Sabha, because remember, the Council of Ministers are collectively responsible to the Lok Sabha. So any procedural motions, whether it is changing the agenda for the day or restricting a minister from saying something, or even questioning the overall confidence, it will only and only happen in the Lok Sabha. It can't even be introduced in the Rajya Sabha. Because if that would happen, then the states would have a role to play in the national stability of the country. And that would violate my larger principle of center stronger than the states. Now, as a small appeasement, the Rajya Sabha also gets certain authorization powers, which basically means unless the Rajya Sabha doesn't do this, the parliament cannot do that. There are two authorization powers. The first is under Article 249, which says that if the parliament wants to make a law on something which is in the state list, it can only do so if the Rajya Sabha is authorizing the parliament to do so. So this would require, again, a special majority of more than 2/3 of present and voting. This is why these are generally called resolution majorities. This is why they're generally called resolution majorities. Now, very importantly, why would you do this? You would do this because circumstances would be such that you would want the Rajya Sabha to effectively authorize the parliament to make a law on something which is extremely important in national interest. Now, why does the Rajya Sabha get to do this? Because the Rajya Sabha is a representative of the states of India. If the Rajya Sabha is a representative of the states of India, then the Rajya Sabha is authorizing, very importantly, the national parliament to do this, right? And this is why it becomes important for the Rajya Sabha to play the role that it does. Now, similarly, the Rajya Sabha also gets a power to authorize the parliament to create a new All India service. And to create a new All India service, the Rajya Sabha can authorize the parliament for doing so by again passing a resolution. Now, as far as the All India service is concerned, it simply means that you're looking at the post of a judge not lesser than a district judge, and you will have an All India recruitment service for it. And that's the larger understanding of what is an All India judicial service for that matter. Now, Again, you would require the same majority for the Rajya Sabha to authorize it. Now remember, these are just authorizing majorities. After this, you will have to make a law giving effect to these majorities. There's no compulsion whatsoever, but you will still have to make a law. Now that the Rajya Sabha has authorized the parliament to make a new All India service, you can now do so by making a law. You could have not made a law if the Rajya Sabha had not passed this resolution. Now, very interestingly, this is very important. The Rajya Sabha has already authorized for the creation of an All India Judicial Service. Now, if at all a law has to be made, it will not be considered a constitutional amendment under Article 368. This is categorically mentioned under Article 312 of the Constitution of India. However, this is how the houses are unequally placed on the whole. This is again an appeasement because ultimately the house has to collectively be passed by both the houses. Now, with respect to state legislatures, the funda is very clear. The funda is that the State Legislative Council has been created at the behest of the State Legislative Assembly. The primary purpose of the Assembly is to provide an enhanced deliberation chamber. The Rajya Sabha is representing the states. So the council is representing the districts does not make any sense. Or the council is representing local governments does not make any sense. Because local governments have their own representation. However, local bodies take participation or take a role in electing legislative councils, but the primary role is that you are a deliberation chamber. That is the primary essence of it. And it should also be the case that you should not abuse state legislative councils and make them retirement chambers just in case you think that because of anti-incumbency, you will not come back to power. So basically, the State Legislative Assembly has priority over everything when it comes to state legislative councils. So ordinarily, for example, even if you have joint sittings here, you cannot have joint sittings anywhere else. It is absolutely not permitted, no matter what. You cannot have joint sittings in state legislatures which have two councils or two houses whatsoever, because a joint sitting would effectively defeat the purpose. It will be counterproductive because the state legislative assembly anyways has more powers than the state legislative council. This is important, has been asked in the prelims a few times, so a comparative review was in fact the order of the day. Now, let us quickly look at presiding officers, importantly so. So, the difference here is, except for the chairperson of the Rajya Sabha, every other presiding officer is elected, removed, and does exactly the same thing. So let's do everybody except the chairperson of the Rajya Sabha, who happens to be the Vice President of India. All presiding officers of all houses, except center and state both, except the chairperson of the Rajya Sabha, are elected by a simple majority of that house. Simple majority is more than half of present and voting. And they're removed through an effective majority of the same house. Now, we know effective majority is effectively total strength minus effective strength, and effective strength is total strength minus death, disqualified, or resigned members. Now, why do we keep effective strength? Because if you're questioning the presiding officers, you should have been functional members of the house. I cannot keep it as simple majority, then it will be very easy to remove presiding officers. I cannot keep it as total majority because some of them are no longer even alive. So the appropriate number to balance stability and accountability is effective majority. So you will remove presiding officers through what is called effective majority. Now, presiding officers are always chosen from the members. they have to already be sitting members of the respective legislatures. And the previous Lok Sabha speaker, for example, will continue to be in office, will hand over the charge to the pro tem speaker, who will conduct the election for the new speaker of the Lok Sabha or the lower house. This is generally the case. There's absolutely no compulsion whatsoever to resign from the political party. They are expected to be politically neutral, but by law are not supposed to be apolitical like the president. Third, lower house presiding officers have an extraordinary power of certifying money bills, which therefore gives the Lok Sabha a certain sense of superiority over the Rajya Sabha. And whenever there is a joint sitting under ordinary circumstances, the first preference is given to the Speaker of the Lok Sabha. Now, whether it is the Lok Sabha or the assemblies, the presiding officers collectively supervise, or the Speaker of the Lok Sabha, for example, is the person under whose direction and supervision the parliamentary committees as a whole function. And the Speaker of the Lok Sabha, more specifically, is the ex officio president of the Indian Parliamentary Group. It is an autonomy body which was actually set up by the Constituent Assembly. And this autonomous body, which was set up by the Constituent Assembly, basically is like an organizational platform where all current members and all ex-members can sit, discuss, and deliberate. It also has the branch of the Commonwealth Parliamentary Association. And apart from this, what is very important for you to understand is that the deputy speakers of the lower houses are not subordinate offices, they are replacement offices. So if the speaker is not available, the deputy speaker will preside and will have the exact same powers as the speaker. Otherwise, they perform a similar broad range of functions. The broad range of functions would therefore be, for instance, they will decide on matters of procedure, they will decide on admissibility of questions, they will decide on whether or not amendments to be taken, they will decide on allocation of time. These are the general functions for all presiding officers. You don't have to worry about them too much because it is too basic to not get right in the prelims exam. Now, as far as the Vice President of India is concerned, the Vice President of India is chosen by a simple majority of both the Lok Sabha and the Rajya Sabha, who sit and vote separately. But the Vice President is dominantly the chairperson of the Rajya Sabha. So if you're removing the Vice President, you're primarily removing because they are not doing a good job as the chairperson of the Rajya Sabha. If that is the case, then you will follow what is called effective majority in the Rajya Sabha. The Rajya Sabha will vote first, will pass the removal motion by effective majority, and then the Lok Sabha will pass the same thing through what is called a simple majority. Rest, the functions are the same. What is unique about the presiding officer of the Rajya Sabha is that the presiding officer of the Rajya Sabha is not a member of the Rajya Sabha. The Vice President, as I said before, is not a member. The Vice President is also a part, and that's something very important. And because you're not the member, you don't have the democratic mandate under rule number 1 to preside over a joint sitting. And if that is the case, then under no circumstances will you be able to even sit over a joint sitting. So I hope that is clear. So when you have a joint sitting, it is the President, Deputy Speaker, Deputy Chairperson of the Rajya Sabha followed by the CGI, but it does not have anything to do with the Vice President even getting an opportunity to preside over the sittings of the Rajya Sabha, the joint sittings, sorry. And as far as common powers are concerned, I've broadly given you an idea. They decide on disqualification of anti-defection law. They're the final authority on procedure and interpretation within the House. They also are responsible for conducting the business of the House, and they enforce discipline through various measures. So this is generally the role of what is called presiding officers. Now we will move to the next topic, which is members. When we start with members of the legislature, we've got to do it in the following headings. First, we have to understand the qualifications, and then we have to understand how they can be temporarily suspended. This has been particularly in the news recently because we've had one of the highest record number of suspensions in our houses of parliament. Then we have to understand that suspension necessarily does not mean that you have been removed as an MP. And when you have been removed as an MP, what happens is that there is a vacancy. Now, this vacancy could be for multiple reasons. And if you are removed as an MP, it is generally because of disqualification. Now, with disqualification, there are three ways you can be disqualified. One is on the basis of core provisions of the Constitution. Two, Representation of People's Act. And three, anti-defection law. Now, this has to be done with a fair amount of clarity because it is sort of important. Now, let us start. When we are referring to qualifications, qualifications for members of the union legislatures are mentioned under Article 84, and qualifications for members of the state legislatures are mentioned under Article 173. Now, the qualifications are fairly common, with the only difference being that of age. So let us understand what is the issue of age and the rest of the qualifications. So, for all houses, you have to be a citizen to be able to contest elections. Now, how you become a citizen is completely up to you. You can be a citizen by birth, descent, naturalization, registration, or incorporation. There is absolutely no problem. But you've got to be a citizen when you're contesting and while you are holding office. Two very important terms. And the oath for MPs and MLAs is given under Schedule 3. Now, what is important is when you refer to Schedule 3, Schedule 3 actually has two oaths for the members of legislatures. One before the election and two after the election. And both of these oaths have to be taken. Before the election, the oath has to be taken at the time of nomination, at the time of filling your papers, before a representative authority of the Election Commission of India. This is generally before the returning officer of the election. But after you have been elected, somebody on behalf of the president will administer the oath to you. Now, apart from that, there is a change in ages. Now, a very simple way to do this is lower houses ages is 25, upper houses the ages is 30, and president and governor the age is 35. If you notice carefully, these are ages in an incremental value of 5. 5 is the ordinary term of a legislature of the lower house. So what happens is the youngest lower house MP and the youngest upper house MP will have a difference of approximately what is called 5 years. And this difference becomes extremely important because this youngest lower house MP and the youngest upper house MP, there is a difference of seeing 5 more years of the world. This does not mean that you've been 5 years in office. It means you're just 5 years older. And because you are older, you will tend to have more wisdom. You will tend to have a more nuanced understanding of the things that happen in and around you. So this is why you have an age difference. So for legislative assemblies and state legislative and the Lok Sabha, it is 25. For the Rajya Sabha and the state legislative councils, it is 30. Now, importantly, as a reflection of rule number 2, center stronger than the states, it is the parliament who can make a law for further electoral qualifications for both the union and the states. Now comes the highly misunderstood part of a suspension. So first things first, when we look at suspension, anybody except the chairperson of the Rajya Sabha could be suspended. Now, suspension happens for all the houses. Now, how and what is the process of the suspension is not defined in the constitution at all. Though suspension is a formal termination from attending that session, it has to be mentioned in the rules of procedure, and it is decided by the presiding officer. Now, the rules are absolutely silent on what if the presiding officer has to be suspended. So it is understood that the presiding officers can't be suspended because you are suspending somebody on the grounds of disorderly conduct. Now, what is disorderly conduct is decided by the presiding officer, as you are the enforcer of discipline in the house. Now, technically, suspension as per the rules of the Lok Sabha and the Rajya Sabha would generally mean that you are suspended for the remainder of the session. Now, does this remainder mean the last date of sitting, or does it mean remainder of the prorogation, the last date when the prorogation order is issued? That is unclear. However, this is what suspension means. Suspension does not make you not an MP. It does not take away any of the powers and the privileges and the benefits that you would have. It is just that you will not be able to attend parliamentary proceedings. That is the primary agenda of what is called a suspension. Now, let us first understand what is a vacancy. Ultimately, even after a disqualification, it will lead to a vacancy. A vacancy means that the seat is not filled. Now, that could be for two reasons. One could be for disqualification. The other could be for duality. So let's understand what this means. As far as vacancy is concerned, there are a bunch of guidelines that have been given. Now, vacancy is mentioned under Article 101 and 190, respectively, for our MPs and MLAs. The idea is if it is a vacancy, then it has to be refilled. Now, if a person is a member of both the Lok Sabha and the Rajya Sabha, then a parliamentary law can be made on deciding which seat has to be vacant. There is no parliamentary law about it as such. Two, if a member is both a member of a legislative assembly and the council, then similarly, the state will make a necessary law. If you are an MP and an MLA, then you have a minimum number of days in which you can tell the authorities that I would want to retain this seat. If you don't inform the authorities about the seat that you want to retain, then interestingly, your MP seat will become vacant. If you're an MLA of two states and you have not been able to define or inform which state you want to retain your MLA seat from, and you can be a resident of two states, which is itself a problematic area to begin with, then unless otherwise, you will have disqualification from both your MLA seats. And that is the important part. That is something that we must understand under all given points of time. So that is it. Now, very, very importantly, because we are dealing with disqualifications also, that is when you have actively removed an MP or an MLA from being an MP or an MLA. But a vacancy is that it could be for a duality purpose. It could be because there is a seat that has to procedurally be left empty. So these are ways that can happen. Apart from this, you can also be disqualified if you've been absent for about 60 days. Now, if that is the case, then you can be removed, but that does not mean that you necessarily have to be removed. And if you are resigning from an MP or MLA's post, then you have to resign to your superior authority, which is your presiding officer. If the presiding officers are resigning as presiding officers, they will send in their resignations to the deputy speaker. Why? Because of separation of powers. Even if somebody resigns as a presiding officer, they will continue to be a member of the House. And that is something we have to be very careful about. Now, when we speak of disqualifications under different heads, a simple way to do this is, who is disqualified you? Here in the first column, you can see that the president or the governor on the binding advice of the election commission is removing you. Even though the advice of the election commission is binding, there is no time frame for the president or the governor to issue the disqualification order, which is why the nature of it being binding often becomes a little transient. Now, you would generally see that the president or the governor will have the powers to disqualify a member on the basis of certain activities that will happen outside the House or will impact the integrity of the House as a whole because of certain actions that are unbecoming of the conduct of an MP or an MLA. Now, generally what will happen is it would be because you're not a citizen, because a competent court, in this case would be the High Court, would declare you to be somebody with an unsound mind. Somebody could be an undischarged insolvent, or somebody could be holding an office of profit. In addition to this, the Parliament can make any law, and in pursuance of this, the Parliament has made the Representation of People Act of 1951. Now, the office of profit. Let me make it very clear. When I say office of profit, I mean holding another office of profit which is not exempted. Office of profit is not a bad term. It simply means you're holding an office, performing a service, in return of which you're getting a certain compensation, perk, or privilege. So therefore, when we refer to office of profit, the problem is if you are holding an office of profit, which is not exempted under a law made for office of profit, then you would be disqualified. And the law is the Prevention of Parliament Prevention of Disqualification Act of 1959. This has been a PYQ question before. Office of profit has not been defined anywhere. There have been several Supreme Court judgments on what is an office of profit. The larger understanding is that there should be an office, you should be holding it, it should be under the government, and you should be paid for it. There have been several Supreme Court judgments giving greater detail in terms of the autonomy and the control and the scope of powers, but that's not important for the pre, very important for the means, but certainly not important for the pre. But the fact remains, you can only be removed if you are holding another office of profit. Now, in the Constitution itself, it is very categorically given that when an MP is also a minister, and you have to be an MP so that you can be a minister, that is also holding two offices. And if that is the case, then it will be exempted constitutionally under office of profit. And that is the essence of it all. Now, having said that, there are a bunch of offices. For example, the vice president is also the chairperson of the Rajya Sabha. For example, the chairperson of the Commission on Minorities. These are all exempted offices. The leader of opposition, the whip, you would often hear of things like, for example, the leader of government. These are all exempted in toto. There's nothing to particularly be worried about. So this is what is called as office of profit. Now, again, when we are referring to certain terms, and these are important terms, for example, when you're referring to terms such as leader of opposition, this is where it generally comes from. Leader of opposition is someone that you have to identify as the presiding officer. But who is going to be the leader of opposition is not defined as per the Constitution per se. So therefore, it becomes an open-ended debate. These are your core constitutional disqualifications. They are given under Article 102 and 191 as far as the Constitution is concerned. Then you have the Representation of People's Act. There has not been a single question from here in the pre. However, it's generally so that if there is a conflict of interest, there are electoral offenses, there are criminal convictions against you, then you would be disqualified. You may also have civil or criminal charges going against you parallelly, but you will also be disqualified at the same time. These are two separate but concurring procedures against you. Now, for example, we've had something called the Lilly-Thomas case. Now, according to the Lilly-Thomas case, it's a watershed case when it comes to tackling criminalization of politics. If you have been sentenced to prison and rigorous imprisonment for more than 2 years, then you are banned from contesting elections for 6 years. Similarly, if you've been convicted under the Protection of Civil Rights Act, you're banned from contesting elections for 6 years from the date of release. So these become very, very important methods. Again, derivations and implementations and interpretations of the Representation of People's Act. Now, the reason Representation of People's Act per se is not asked because it does not strictly come under the prelims syllabus, but it definitely does as far as the mains syllabus is concerned. Then comes the presiding officer. The presiding officer will decide on questions of anti-defection law. Anti-defection law are a bunch of provisions inserted in the Constitution through the 52nd Amendment of 1985. And this added the 10th schedule and, of course, correlational lines to 102 and 191. But what is the important part? The important part is anti-defection law is applicable to every member of the legislature except the chairperson of the Rajya Sabha, because the chairperson is the vice president and you have a dedicated removing process, and the chairperson is the only person who's not a member of the houses but is actively participating in conducting the proceedings of the houses. Now, there are basically 4 grounds. The grounds have also been a matter of judicial scrutiny. So the first ground is giving up membership of the party. The courts in the Ravi Nayak case have also interpreted it and said giving up membership is not just resignation, but also beyond resignation. That actions speak louder than words. So if you are behaving in a manner, talking in a manner, conducting yourself in a manner which is contrary to the political party that had on whose ticket you had won, you could be disqualified from the house. 2, if you are violating party directions. Now, party directions are issued by somebody called the whip. Now, each political party or coalition is going to have a whip. The purpose of the whip is to coordinate collective actions in the house, because the necessary outcome of parliamentary democracy is actually a party democracy. Otherwise, you will not be able to get the necessary numbers that you absolutely need. So this could be violating a whip. This could also mean violating any other order that can be the case. A whip can be issued for everything, does not necessarily mean that a whip should be issued for everything, right? And that's the second criteria. Thirdly, an independent member, if an independent member is joining any political party. See, when you contested elections, you told your constituents that my political association is that I have none. I have no aspirations of ministership. I have no aspirations of having aligned with a larger political party. And therefore, when I say that I am seeking your vote so that I can work with you within the constituency and raise the issues of our constituency at the Lok Sabha, I truly, truly mean it. And if this is what you truly, truly mean, then in a scenario like that, I cannot under any circumstances whatsoever violate that fiduciary trust. So an independent member does not get any opportunity whatsoever to join any political party. And a nominated member has been nominated on expertise, has not been nominated on political association. So they also deserve a chance. So they get a chance to choose any political party within 6 months from their date of joining. Now, from their date of joining, they can mix and match, try and error, do whatever it takes. But after 6 months, if they want to, they by 6 months they can join a political party. After 6 months, if they haven't joined a political party, they cannot join again for the tenure. If they have joined a political party, they will stick with the party that they have joined. The only exception to anti-defection law is if two-thirds of the members of a political party have joined another political party. If that is the case, then that is allowed. And the remaining one-third will not, under any circumstances, be allowed to form a new party or join a new party. It's a state of limbo per se. And if you have been disqualified from on grounds of anti-defection law, you can always contest an election and come back again. Nobody is going to stop you. And two, if you've been disqualified on anti-defection law, then any other post that you would have been holding because you were an MP and was exempted under anti-defection, under Office of Profit, you will have to also let go of those posts because you got those posts because you were an MP, not the other way around. So that's generally the understanding of it. Who decides? The presiding officer decides. And if at all it is a case of defection of the presiding officer, then the House will choose somebody else to preside over the proceedings. The deputy speaker will not. It is categorically given in the text of the 10th schedule. And as obvious, because of principles of natural justice, there is no time to decide. So the Supreme Court in multiple judgments very recently also has said that you should do it in 3 months. If the presiding officer wants, they can also set a time, but constitutionally there is absolutely no limitation. The original text of the 10th schedule had said that a decision of the speaker is final and binding. But the Quijotto-Zolohan case of the Supreme Court has invalidated this provision, and therefore the Supreme Court can effectively get into examining the decision of the speaker on anti-defection law, can overturn it, but the Supreme Court cannot get into the procedure that the presiding officer has used. The Supreme Court cannot get into how the decision was made. They can only get into what the decision was. And that itself is a very, very important point of inflection. So this is generally how members work. See, the point of this lecture is the legislatures are magnanimous topics, but only very few things are asked from these magnanimous topics. So the difficult part in legislatures is consolidating it, is putting it all together in one place so that you can easily do them right. So this is generally how it works. This is how your members are chosen, removed, etc., etc. But at the same time, you have something called immunities and privileges. This is important. See, immunities and privileges, contempt of court, and defamation are three sides of the same coin. So let's understand what this is. First things first, a privilege is anything. So a privilege is what you have as an MP or an MLA, the ability to participate in the House. So anything that takes away your ability to participate in the House properly, with the greatest rigor, without any disruption, is a breach of privilege, which is why privileges are greatly related to what are called parliamentary disruptions. Now, let's get our facts right for the prelims exam. Privileges are not singularly codified anywhere, nowhere whatsoever, which means it does not mean that there are no laws on privileges. There are laws. The problem is they're scattered. You have a few things written in the Constitution. You have few things written in other laws, such as the Civil Procedure Code. You have a few number of things which are conventions. There are some British parliamentary conventions also that you follow. The problem is we do not have a single law on this, though the parliament can make a law, but the parliament has chosen not to. Now, let's take a few examples of what it is, and then I'll explain how does the process work. So, for example, in the Constitution, you have something called your protection from how you vote and how you speak on the floor of the House. You also have the courts who are barred from getting into the proceedings of the House, Article 122. And if you're doing a true publication of House proceedings, then you are not going to be charged with anything. And this gives you the difference actually between immunities and privileges. Immunities are protections that are given to you so that you can do your job. Privileges is anything that stops you from doing your job, any external element. So privileges are external and immunities are generally internal. Again, if you look at other laws, for example, Section 135A of the Civil Procedure Code very clearly says 40 days before the session and 40 days after the session, you cannot be arrested. The rules of procedure also clearly mention that the presiding officer must be informed of the fact that you have been arrested and so on and so forth. See, the core rationale behind the recognition of legislative privileges is to protect the lawmakers from interference by others in the discharge of their essential functions. This could be intrusions by the executive branch, it could be intrusions by the courts, it could be intrusions by private parties. So privileges is a larger term, right? And therefore it becomes extremely important, which is why you have so many provisions around it. Similarly, based on precedent, you cannot be compelled to be a witness or give evidence without the permission of the House. There are also a few things which are generally considered not a breach of privilege. For example, if you're banning a procession outside the Parliament's house, that's not a breach of privilege. For example, internal party matters, that's not a breach of privilege. And all of those things effectively tell you how open-ended the larger concept of privileges is. So the question is, who decides? It is the House who decides. How? Once an issue of privilege is brought to the notice of the presiding officer will refer it to the Privileges Committee. And the presiding officer will then wait for the report of the Privileges Committee. And then the House will take a collective call. The Privileges Committee will recommend the outcome of punishment. Sometimes it could be a warning, sometimes it could be a reprimand, sometimes the House can also give you criminal punishment. So when you are acting as a chamber deciding a privilege, you're also acting in a quasi-judicial capacity to say so. Which then brings me to the larger part. Who is violating what? The violation of the House or the violation of the member? Who's violating it? Either the members are violating it or of each other or non-members. These non-members could be courts, they could be private parties. So what is a breach of privilege? So breach of privilege would be when the privilege of the House or the member is violated, or a member is violated by the member itself, right? By interfering, or even by a non-member. It then becomes what is called a breach of privilege. But if the privilege of the House or the presiding officer or the proceedings, they are being violated by the members or non-members, it is called contempt of court. So what is the difference? A breach of privilege is generally against an MP or an MLA. And a contempt of parliament is against the House as a whole or the presiding officer or the procedure contained therein. The outcome is that every breach of privilege is also a contempt of parliament. But every contempt of parliament is not necessarily a breach of privilege. And because it is uncodified, the House can decide on either of these matters and so on and so forth. So this is the larger concept of immunities and privileges. Again, to keep it very simple, if the integrity of the house or the member is violated by a fellow member, you're not letting the other person speak, you're violating privilege. It's that simple, right? Or if a non-member is saying something terrible about a member, it is a breach of privilege. If a non-member is say publishing, let's say there's a newspaper report which is saying very bad things about the speaker, about the house, about a member, it is generally called contempt of house or contempt of the parliament. So this is generally the understanding behind it. Now let's get to procedures. See, basically you have term, session, sitting, and agenda. The basic understanding is for lower houses, the term is 5 years. Year 1 plus year 2 plus year 3 plus year 4 plus year 5. In each of these years, you have sessions. Session 1, session 2, session 3. In each of these sessions, on a specific date, you have what is called sitting. You will see rule number 3, separation of powers, to be very categorically applied here itself. So let's understand how this works. When we're referring to term, this is what we are referring to. The term or the tenure is 5 years for the lower houses and it is permanent for the upper houses, as we have discussed. So we are not particularly worried about it. When you are officially ending the term, it is called dissolution. And therefore, a formal dissolution order has to be issued by the president or the governor, depending on Lok Sabha or state legislative assembly. Now, there are two kinds of dissolutions: automatic dissolutions and circumstantial dissolutions. Automatic dissolutions are a formality, which basically means that after your 5 years is over, automatically the Council of Ministers will go and will therefore collectively as symbolically submit their resignation, will say that we are now done, and then the president will issue the dissolution order. That's the simple automatic way to go about it. The issue is with circumstantial. See, the principle is the Council of Ministers are collectively responsible to the Lok Sabha. It is not the other way around. So if the Council of Ministers are resigning before 5 years, or there is a no confidence motion passed against the Council of Ministers, and it has been successful, it means they don't enjoy the confidence of the House. It does not mean that the House is dependent on them. So this is why a no confidence motion or a confidence of motion, either ways, by passing or failing either of the two, it does not necessarily lead to dissolution. Then what will happen is the president or the governor will try to conduct a floor test, will try to invite, they'll wait for people to come and say, we have majority, let us make government. If that does not happen, then finally you will have a dissolution. However, at the level of the states, you can also dissolve under Article 356. We have discussed this before also, but this is only and only for the states. Similarly, resignation of the Prime Minister or the Chief or the Council of Ministers does not necessarily lead to the dissolution. Resignation of PM leads to the resignation of COM is okay, but resignation of the PM necessarily leading to dissolution, that is also not okay. So what happens is when the House is dissolved, then the legislative mandate is dissolved. So you have to apply rule number 1, which is democratic mandate. And by rule number 1, when the Lok Sabha ends, so any intent and mandate of the Lok Sabha ends. So what is saved? All bills except those which are introduced and pending in the Rajya Sabha lapse. So if there is, for example, Bill A. Bill A was introduced in the Lok Sabha, passed by the Lok Sabha, then sent to the Rajya Sabha, right? Now it is currently pending in the Rajya Sabha. It is currently being discussed by the Rajya Sabha. The idea is it will still fail because it will still lapse because the Lok Sabha is gone, so the prior intent is gone. The next government can come and introduce it, and that's okay. The only thing that does not lapse is anything which is introduced and pending in the Rajya Sabha. That's the important part, right? Now, there is something called government assurances. Now, what are assurances? Assurances is when questions are asked to ministers, the ministers give an assurance reply saying we will sort this out in 2 months, in 1 month, in 3 months, in 8 months. So they are promising a solution to a problem on the floor of the house. So these solutions go beyond the Lok Sabha because these are solutions of the government. The solutions must carry on. They've already been promised. They do not require legislative sanction, which is also why whenever government assurance committees are reconstituted, the assurances are also carried over. So that's something that you must always know. So assurances lapse, but every other agenda of the committee, any other parliamentary committee mandate, subject that they were getting into, it does not go anywhere. Now, sessions. How you dissolve a term is how you prorogue a session. Now, a session is a formal end to a collective sitting, and it is also issued by the president and the governor. Now we can answer the question, why the president and the governor dissolve and prorogue? Because when you're dissolving, you are ending the legislative mandate. And when you are proroguing a session, you're ending the procedural pendency of that tenure. Now, if you had left it to the presiding officers, they would either prolong it or end early, depending on what the political mandate is. Nobody else can intervene because of separation of powers. So the only option that we left are with seemingly apolitical people, the president and the governor. Now, the constitution very clearly says there has to be a gap of maximum 6 months, which means you have to have minimum 2 sessions a year. This is based on provisions of the Government of India Act of 1935. But what we do by convention, this is not written anywhere in the constitution. It is by simple convention that you will have 3 sessions a year, the BMW sessions, the budget, monsoon, and winter sessions, and generally they are in descending order of length. Budget is the lengthiest, then the monsoon, and then the winter. Now, there is absolutely no fixed parliamentary calendar, which means there is a cabinet committee on parliamentary affairs who will collectively decide on when should the houses come to sit. It's because, and this is a very fine balance, it's because when the houses are sitting and the Council of Ministers are responsible to the houses, more specifically to the Lok Sabha, the Council of Ministers are also running government. So they would want to keep it at a time where they can give their complete time and attention to the proceedings of the Lok Sabha. So that's the first part. The second part is it also gives you a sneak peek on how we are really a cabinet form of government and not really just a parliamentary form of government. Now, after a session is prorogued, nothing happens to the legislative or the committee pendencies. They continue, they get carried forward. Now, if there are any disqualification proceedings, they will then be taken up in the next session. Everything stops until the next session. That's basically what happens. Nothing is permanently stopped. And then you have the concept of a sitting. Now, what generally happens in a sitting is this. It's on a specific day. So you're basically stopping the house from sitting that day. They come, they're sitting in their chairs comfortably. You're saying, go back home. If they tell you, come back tomorrow, it's called adjournment. If they tell you, we will let you know when you have to come back, it's called adjournment sine die. And because this is an internal house proceeding, so separation of powers will apply. So the presiding officers will decide on adjournments. Now, for the house to sit and do anything, you require minimum 1/10. Otherwise, 5 people can come and pass a no confidence motion and it will be gone by the end of the day. So you keep something called as a quorum. And two, it is nothing but convening the house on a specific day. It can also be, you can also adjourn and say, we'll meet day after tomorrow, or we'll meet, let's say, on 20th of February, or 21st of February, or 18th of February, whatever it could be. So that's how it works. Now, what you do on that day is effectively called an agenda. Now, an agenda is very, very simply nothing but the business of the day. What is it that you're going to do? So if you want to stop the house from discussing what they were supposed to discuss, you will pass what is called an adjournment motion, right? Now, as we know that agendas are set by the Cabinet Committee in the Ministry of Parliamentary Affairs. So if you're changing the agenda, that means you are effectively making the House discuss something that you want to and not what the ministers want you to. So in a way, it is a question mark on the confidence of the ministers, which is why these adjournment motions are only in the Lok Sabha and the Rajya Sabha. Whereas these are also, because these are motions and all motions require simple majority, they are passed accordingly. Now, if this is the case, then we must also understand the general tenure of the House. So how does this work? Generally, the House sits at 11 a.m. From 11 a.m. to 12 p.m. is one session. From 12 to 1 p.m. is the other session. 1 to 2 p.m. is the other block. From 1 to 2 p.m. is lunch, and from 2 p.m. onwards, you have what is called the legislative business. Now, generally, all of this is regulated by rules of procedure. So the chances of you shuffling things around is completely okay, and you're completely free to do what you want to. There's absolutely no problem whatsoever. So generally what happens is that you will see in the first between 12 o'clock to 1 o'clock, you will dominantly see 0 hour and question hour. Now, generally question hour happens first and 0 hour later. Sometimes it can be interchanged. The basic difference is in a question hour, you have predetermined questions. The whole point is Council of Ministers are collectively responsible to the Lok Sabha. So you're going to ask questions to the Council of Ministers. Now, these 0 hours and question hours will happen in all houses because asking a question doesn't take away your confidence, right? So this is why. So 15 days, 20 days before you will submit your questions. Now, if the questions require a verbal answer, it will be a starred question. It will, if it requires a written answer, it will be an unstarred question. Now, generally, you entertain about 20 starred questions and about 230 unstarred questions on a given day. But again, that fluctuates from day to day and the general performance of the House. A 0 hour is an innovation of the Indian Parliament. It is called 0 hour because it's closer to the 24-hour representation of 12 o'clock, where it is not predetermined. Anybody can ask anything to anyone. That's why it's called a 0 hour. Now, after that, you break for lunch, and after that, you have legislative business. Now, the Lok Sabha generally sits till 6 p.m. The Rajya Sabha generally sits till about 5 p.m. Sometimes you have a dedicated block of time purely kept for private member bills. I'll discuss what they are in just some time. So basically what is happening on a day, you're looking at certain bills, you're looking at some motions, and you're looking at some resolutions, and you're giving some assurances. Motions and resolutions are two of the spinal cords of parliamentary business. Everything starts and ends with the motion. That's the idea behind it. And a resolution is nothing but reflecting the will of the House. So let's first start with the basic core business, which is bills. Now, to understand bills, one could look at it in multiple ways. You could look at bills in terms of what they have. For example, original bills, amending bills, consolidating bills, expiring bills, repealing bills, validating bills, bills to replace ordinances, money and financial bills, constitutional amendment bills. These are the different types of bills on the basis of content. For example, a consolidating bill will merge multiple laws into one. A repealing bill is to remove a law from being operational. A validating bill is to give legislative effect to an executive decision. An ordinance replacement bill comes with a time clock that you need to pass it within 6 weeks of the first date of the next session of the House. And then, of course, you have money bill and financial bill, which contain effectively allocations which are financial in nature. On the basis of procedure, you can have ordinary bill, money bill, financial bill, constitutional amendment bills, and bills replacing ordinances. On the basis of who's introducing them, you can have a government bill and a private member bill. Now, a government bill is a bill which is introduced by a minister who's an MP, and exclusively bills relating to the budget can only be introduced by government bills because it is the financial action plan or the fiscal action plan of the government. Whereas private member bills could literally be introduced, any bill could be introduced by anyone. So any bill which is not a budget could be introduced by anyone. And private members are those MPs who are not ministers. So this means you could still be a member of the ruling party and not be a minister. And if you introduce a bill, it is called a private member bill. Now, an ordinary bill is a bill which is not a money bill or a financial bill. So it basically contains no financial allocation. So what is a money bill? Please do not memorize the technical definition. It's given under Article 110, but what does it broadly say? If you're adding or subtracting if you're putting in money or if you're taking out money from the Consolidated Fund of India, appropriation or the custody of it. So consolidated fund, contingency fund, if you're adding or decreasing tax, or there is an issue of parliamentary borrowing, you're borrowing some money as the parliament as a whole, it's a money bill. Now, what generally happens is once a bill for this is prepared, it is sent to the speaker who will certify it. Then this is to ensure that this is truly having a very strong financial implication. The reason the speaker certifies it is because it is the Lok Sabha who's going to have superior powers. And you expect the speaker to be neutral about it so that you're not using a money bill to bypass Rajya Sabha. Once the speaker's certification is assured, it is then sent to the president for a presidential recommendation. Now, a presidential recommendation is needed before you introduce a money bill into the parliament. And that is largely because a money bill is going to have a national impact and a national financial impact. And the president is an apolitical authority who's been elected by the center and the states together. So therefore, a prior recommendation is needed. Hence, a money bill. Now, a money bill can only be introduced in the Lok Sabha first. The Lok Sabha will pass it, will send it to the Rajya Sabha for the next 14 days. In the 14 days, Rajya Sabha has the powers to suggest any changes, any amendments, additions, deletions, etc., etc. And if they do, they will then send it back to the Lok Sabha. It is now up to the Lok Sabha to accept or reject whatever the Rajya Sabha has sent. Depending on the case, the bill is then again passed by the Lok Sabha. If there are any changes, approving or disapproving of those. If you're disapproving those, then you're not going to pass the new bill. You will say that we'll do what we wanted to. And then you send the bill to the president. Now, the president can either say yes or the president can say no, but the president cannot return. Now, why is this the case? Because it could become counterproductive. The money bill being returned will go back again to the superiority of the Lok Sabha, where the Council of Ministers have a clear-cut majority. And the president also has no independent powers. So the Council of Ministers are saying no and are saying return. They will never say return a money bill because they're anyways going to have a superiority in the Lok Sabha to make it pass. So that is why. And just to give you a little bit more insight, Budget bills are also effectively types of what are called money bills. Budget bills are also classifications. So your appropriation bill, your finance bill is a type of a money bill. Now comes the technical bit. What about a financial bill? First things first, the difference between financial bill A and financial bill B is not particularly in our syllabus. But let's understand this. A financial bill effectively has of two types, financial bill A and financial bill B. What it simply means is money bill plus something else. Now, the entire concept is plus something else. Now, let's understand. What generally happens with financial bill A is it's basically like a money bill without these heavy restrictions of a money bill. Now, what is a financial bill A trying to do? It is simply saying we want to spend some money and we want to do something else which does not require money. So that becomes financial bill A. Now, in a situation like this, you will still require a presidential recommendation because of the financial nature. But because you're doing something else which also has enforceability value, you will introduce it in the Lok Sabha first, but both the houses are going to have equal ways to vote. And then you have something called financial bill B, that you're spending money from the CFI in a way that it is not appropriation. You're spending money from the CFI beyond the budget in a simpler way of understanding it. Because of the financial nature, a presidential recommendation is needed, but then it can be introduced in either houses and both houses can vote on this with equal powers and purpose. Now, very importantly, and this is where it gets interesting, a constitutional amendment bill. A constitutional amendment bill can be introduced by anyone, no matter who they are. Doesn't matter who they are, anyone can introduce a constitutional amendment bill. But the idea is a constitutional amendment bill, once passed, the president necessarily have to give an assent. And even if you're amending the constitution in such a way that it will have a financial impact like a money bill, the constitutional amendment will override the effect of a money bill. So therefore, you will effectively be passing it with either a special majority 2 or a special majority 3. This is an important point, mostly not given in most of your textbooks, as I recall it to be. So these are effectively what are called bills. Now we move to something called motions and resolutions. So let us understand what are motions and resolutions, what is the point of it, why do we do this, and please understand this with great depth because there is not a lot of clarity on it. So let's start. See, the term motion in its widest sense means any proposal which is made for the purpose of eliciting a decision of the House. And in order to ascertain the will of the House in regard to a matter before it, every question to be decided by the House must be proposed by a member in the form of a motion. So a motion to remove a Supreme Court judge, a motion to discuss this bill, a motion to discuss this issue, a motion to introduce an amendment. A motion becomes extremely important when it comes to things like these. Now, let's understand this in a greater amount of detail. So, every matter which is to be determined in the House by the means of a question is put from the chair on a motion which is put forth by a member. Now, the question should generally tell you what is it that you want to do. In fact, a motion is the basis of all parliamentary proceedings, everything. Generally, the discussion on a motion is led by or is initiated by the mover of the motion, or unless the person has withdrawn it or the House has adopted it in toto, you can effectively carry on with the discussion. Now, generally what happens is, for example, there are motions that have to be put to vote. There are also motions that are generally sometimes not put to vote. There are some of these exceptions. I'll tell you what they are. So motions are generally classified into three categories. You got substantive motions, substitute motions, and subsidiary motions. A substantive motion is a self-contained independent proposal submitted for the approval of the House, and it is drafted in such a way as to be capable of expressing a decision of the House. So, for example, all resolutions are actually substantive motions. I'll give you an example. For example, this House expresses its confidence in Council of Ministers. That is a confidence motion. So the motion has to be framed very, very properly. A substitute motion, on the other hand, are motions which are used in substitution of the original motion. For example, there's a change in policy, or for example, there is a change in certain scenarios because of which you would want to change the way things have to be understood. You're changing basically what the House is currently discussing. Then you have something called a subsidiary motion. A subsidiary motion could be an ancillary motion, a superseding motion, maybe an amendment motion. Effectively, it could be, for example, ancillary motions would be these are essentially recognized as practices of the House. So a bill be taken into consideration, a bill be passed for that matter, all of those things. Superseding motions would be, for example, a bill to be resubmitted to a joint committee, a bill to be circulated for let us say, public opinion before we do anything else. These are generally called, subsidiary motions. The technical details are generally not important. And subsidiary motions, as we understand it to be, are effectively to create further action on an ongoing agenda, right? Now, motions are generally admitted. There are general forms and procedures around it, which I don't think are particularly important as far as the exam is concerned. Now, you will have different kinds of motions that are generally raised for different things. For example, you will often hear of something called a short duration motion. A short duration motion is to have a discussion on something which is important, of an urgent public matter, and you want the House to discuss it. That is generally called a short duration discussion. It's generally done is without a motion or without even a vote. So sometimes you can have a short duration discussion. This is under, if I remember correctly, 193 rule number of the Lok Sabha and 176 of the Rajya Sabha. Then you have a very, very interesting matter where you would have something called Rule 377 of the Lok Sabha and 180 AE of the Rajya Sabha, where you can discuss matters of general public interest, issues with respect to a ministry, etc. They can generally be raised. Then you also have something called a calling attention motion, where you basically want, with the permission of the speaker, you want to call the attention of a minister to an urgent matter. And the minister can generally then give you a public statement on it. Generally, those matters which are the concern of the union government can be called through a calling attention in the parliament. The government also gets enough opportunity to present its case, and generally a calling attention motion is not voted on. So these are the different kinds of motions that exist. Some of them are actually not voted on. And then you also have a no day yet named motion, which is basically where you're admitting a motion saying that we will discuss on it whenever we have some time. There is absolutely no hard and fast rule for it. And then you have motions that have to compulsorily be voted on. These are restrictive motions. And these restrictive motions are adjournment, censure, and no confidence. Only in the Lok Sabha because of rule number 2. All motions, if at all, have to be passed through a simple majority. The resolutions can have different majorities, as the case might be, absolutely. But this is generally what is called a motion, right? Now, a restrictive motion would be if you're stopping the agenda for the day, adjournment, stopping a minister, then agenda, then censure. And if you are generally having a problem with the collective council of ministers, then no confidence. If the no confidence motion is passed, then the Council of Ministers most certainly will resign. Then you have resolutions. Now, once you have, so the idea is every question, when agreed to, becomes either an order or a resolution of the House. And therefore, these resolution is one of the procedural devices to actually raise a discussion and to actually have some intricacies or some you would say developments with respect to the House. Now, resolutions can be of three types. You can have private member resolutions, you can have government resolutions, you can have statutory resolutions. Now, private member resolutions are those which are moved by private members. Generally, you'll have a separate ballot of it, and the House will separately vote on it. A private member resolution is again the resolution of the House to do something uh, by the private member. A government resolution, though there is no notice for it, it simply is there are multiple reasons why you could have it. For example, a government resolution would be to approve an international treaty. For example, it would be to approve the fact that a treaty has been ratified, to seek permission on all of those. Um, uh, let's say there's an international court that has given an award. There could be a resolution that says, you know what, we don't want to do this. Similarly, you will have statutory resolutions. Statutory resolutions are those that would sometimes you would require, which have the effect of a law. For example, a resolution on an Essential Commodities Act, or let's say a resolution to authorize the Parliament to make a law on the state list, a resolution to now discuss the removal of the Supreme Court judge, and so on and so forth. So that is how it works. Now, you should just know that these are the types, and broadly, this is what they do. If at all, there has to be a question. And then finally, you have what are called assurances. Now, see, assurances are fairly simple. You are asking questions to the minister has to reply to your questions. Now, if the minister has to reply to your questions, you're generally asking the minister, why this not done? When are you going to do this? All of those things, right? So that is generally done through assurances. Now, an assurances has to be completed. Generally, all assurances given must be done within 3 months. And if it is pending, even if the House is dissolved, it is carried forward. So lower house assurances are carried forward. So assurances are nothing but a commitment given by a minister on the floor of the House that it will be done. And that is also why you have a committee on government assurances to monitor all of this in the larger scheme of things. So this takes care of what are called your basic parliamentary tools. Once we've understood the parliamentary tools, we must now move to understanding legislative passages, structures of government accounts, parliamentary business as a whole in terms of committees and so on and so forth. So we will now start. So when we do the structure of government accounts, we simply answer a basic question. Where does the money finally get stored and where does the money finally get spent from? So this is the epicenter of it all. It's called the Consolidated Fund of India. From the Consolidated Fund, a certain section could be earmarked for contingencies. Through law, you will put the money here in a contingency fund. Then the executive can keep spending from here depending on the contingency. To spend from the contingency fund, you do not require parliamentary approval. But after you have spent it, later on, you can again present it before the parliament. The basic principle is that if the Council of Ministers are collectively responsible to the Lok Sabha, responsibility would primarily lie in how you are financially allocating the resources that you have the custody of, since you are the government of India. Apart from this, the government also keeps something called the public account of India. Now, this is the money which does not belong to the government, but actually belongs to the people, and the government keeps it in their custody. For example, Public Provident Fund. For example, money from the pension scheme. This is kept with the public account. Now, When we look at the consolidated fund would largely have money coming in and money being spent over a short period, less than a year, and does not affecting an asset. This is called revenue, receipts, and expenditure. And it will also have money coming in and going out over a longer period, which is more than a year, and affecting an asset. This is called capital receipts and expenditure. Now, this is the primary. It is from here that you will give money to ministries for the budget. It is from here that you would sometimes ordinarily spend money, therefore financial bill category B. But the epicenter for financial corpus is the Consolidated Fund of India. Now, there are two kinds of expenditures that you make from the Consolidated Fund. One, expenditures which are charged to the Consolidated Fund, and expenditures which are made from the Consolidated Fund. Made from means it is depending on the circumstances, depending on the reason. So generally, demand for grants, which is something that you would use in the budget, is an expenditure made from the Consolidated Fund. It could be from time to time, it could be for any reason whatsoever. Whereas expenditure charged to, now understand this, this is discussed but not voted. But what is the primary concept behind? If you want to preserve the independence or the autonomy of an organization, the best way to do that is to give them financial freedom. So organizations or institutions that require that autonomy will be given the benefit of expenditures charged to. By doing this, you will ensure that they don't have to worry about finances to do their job. So who would they be? So for example, the salary allowances and the emoluments of the president in the office, because they're performing a check and balance function. Presiding officers, because they're expected to be impartial. Supreme Court, High Court judges, so that they can truly be an independent and an integrated judiciary. The pensions of High Court, as the pensions of Supreme Court judges. Now, this is important. See, what generally happens is the Supreme Court and the High Court will have salaries and will have pensions. The salaries of Supreme Court judges are with the Consolidated Fund of India, and the salaries of High Court judges are with the Consolidated Fund of the states. But the pensions of both Supreme Court and High Court judges are with the Consolidated Fund of India. This is to again promote and protect impartiality. By law, you are not allowed to practice in the High Court where you were a judge. So you cannot work in that state. So it has to be ensured that your basic needs are taken care of. So this is why salaries and pensions of High Court judges, salaries and pensions of Supreme Court and High Court judges, and salaries of Supreme Court judges are charged to the Consolidated Fund of India. Apart from this, the debt charges that the government incurs, they also are charged to the Consolidated Fund of India. That means they are discussed as a symbolic nature, but in the budget, now this is important, in the budget, they cannot be reduced to their disadvantage, and ordinarily during that term also, they cannot be reduced to their disadvantage. And salary allowances and the pension of the CAG being the only office which performs an active checks and balance function of the works of the elected executive. The basic principle is that you require a parliamentary law to add or withdraw from the CFI, which is why you will see reflections of it in the money bill or even in the financial bills. Now, this is the importance of the structure of government accounts. As far as the prelims is concerned, we have seen some basic questions from charge to, but nothing beyond that. Now, let's go and understand very, very simply what the basic process is and how do we actually go through it. So let's get this right. First things first, let's understand the passage. Now, we don't have to get into too much technicality, just the basic passage is important. Why has the prelims never asked a dedicated question on the passage of a bill? That is because it will eventually depend on how the House wants to go about it. So, for any bill and for the budget, there are two different distinctions because the budget is not only a law, but it is also a policy document in a manner of speaking. So, let's now understand what is it that they do. Basically, the draft of the bill is prepared. It could be a government bill, it could be a private member bill, it does not matter. Now, from the draft of the bill, what will generally happen is the final draft would be ready. It would then be introduced in either of the houses, either Lok Sabha first or Rajya Sabha then, or Rajya Sabha first and then Lok Sabha then. And once it's passed by both the houses, you can give assent, you can say no, you can return. Now, generally what happens is there are three stages. Now, these stages are actually not important for the exam. In the first stage, you have the introduction. Now, this is generally done on a motion which is moved by the minister or a private member. In the second stage, you can effectively do anything you want to. You can directly start discussing the bill. You can then refer it to any committee, a select committee or a joint committee or whatever it is. You can also elicit the bill for a public opinion. You can also take amendments. And then you finally have the third stage, and each house is going to have the first stage, the second stage, and the third stage. You can then discuss on the finality of the bill. Now, in legislative matters, both the houses enjoy equal powers, except in the case of a money bill. Now, what generally happens in a money bill is, as you've already discussed, you'll have a presidential recommendation first, and then the Lok Sabha will have overriding powers over the Rajya Sabha, and the president cannot return, but can only and only say yes or can say no. Now, with the budget. See, the budget becomes a special kind of a law. Budget is of course governed under Article 112, but it's very important for you to understand what it is. The technical term of the budget is the annual financial statement. Now, this becomes important for this year given the fact that it is an election year to begin with. Now, the annual financial statement is also called the budget, and it basically gives an estimation of the receipts and the expenditure of the central government. The states will have their own budget with respect to the financial year. Generally, what happens is that the president will cause for this budget to be laid before the houses of the parliament. So you must understand the budget is presented before the houses because it is going to have a national impact. But the houses are not going to have an equal role in the budget because the budget is effectively a type of a money bill. So that portion of the budget, which is very close to a money bill, are the areas where the Rajya Sabha will not even get a fair chance. Now, since 2017, the railway budget has been merged with the general budget, and now you only have what is called the union budget at the center. Now, the budget will primarily have two laws that the government has to pass: the appropriation bill and the finance bill. Now, sometimes what generally happens is an appropriation bill is basically money from the CFI that is being spent. Now, this could be spent for two reasons: expenditure made from or expenditure charged to. Now, if the expenditure is made from, it is essentially made to ministries. So this is called demand of grants. So this demand for grants is effectively the closest you have to a money bill, which is why you require a presidential recommendation. And to formulate these demand for grants for internal checks and balances, the departmentally related standing committees will of course play a vital role. Now, the finance bill is nothing but a legislative proposal for any tax changes or literally anything else. Any financial policy change, anything could be included in the Finance Act. You would have recently heard of the Finance Act, which was questioned in the electoral bonds judgment. This is why. Now, this entire setup is for one financial year. Now, if the government is going to change in June, then in March, you can't be deciding how much money has to be spent from April till March next year. So what you will do is you will have an interim budget during the last year of the fifth year of the Lok Sabha. And this interim budget is also correlational to something called vote on account, which is basically a temporary expenditure until you have the final budget or you have a proper budget for the year. So basically in 2024, you have one budget, which is from, say, April till about June. Then you will have the second budget, which is from June till about March. So really, the really popular, the really big budget is going to be 2025, and this is nothing but an interim budget, because even when the new government comes, they will just barely have time from June till March. It's about 9 odd months to run the case. Now, the budget, as I told you, is also a financial document, which means it'll contain some very important elements. First, it'll have an annual financial statement. It will summarize the expenditure and the receipts of the government. It will have the demand for grants, which is the detailed estimate required by the ministry for their expenditure. This demand for grants is examined by the DRSCs. You will have a finance bill, which details any changes to the existing tax laws of the country. Then this finance bill is effectively called the Finance Act. It's not the same thing as a financial bill. Then we've passed a law called the Fiscal Responsibility Budget Management Act in 2000, early 2000s. Because of that law, which effectively promotes better fiscal responsibility, that you earn more and you spend less, you have to attach 3 documents with FRBM. First, you have to attach a macroeconomic framework statement, which gives you a larger overview of where the country is going and how do you plan to use your resources. 2, you have something called a fiscal policy statement. Now, a fiscal policy statement will ensure as to whether the amount of money that you are trying to allocate, what is the rationale behind it. And you will also have something called a medium-term policy statement. Apart from this, you'll also have the expenditure budget, which is the larger term, and demand for grants are actually a part of the expenditure budget, wherein you will have the details of expenditure and the departments, including the demand for grants. It will have both expenditures made from and charged to the CFI. It will also have a receipts budget, which will have essentially how are you going to be making money. It will have a tax and a non-tax income budget. It will also have an expenditure profile. It will have a memorandum explaining the provisions of the bill. It will have an overview and so on and so forth. In fact, the budget can be presented to the House in 2 or more parts. And if it is done so, then you'll have to deal with it as if each part were the budget. Apart from this, you can have supplementary, additional, excesses, exceptional grants, etc., to be given, and they're regulated by the same procedure as it is the case for demand of grants. The basic idea is you are going to be spending money. Now, dominantly, it effectively becomes a money bill. So the general process is the finance minister will make a speech after the president has laid for the budget to be presented before the House. It will generally be a longer speech explaining the outcome of it. The budget is then laid on the table of the houses, and once the budget is being discussed, then you have the first step, which is the general discussion process. Now, generally what happens is, in consultation with the finance ministry, the Ministry of Parliamentary Affairs will fix the dates for the general discussion of the budget. Now, the discussion in the general discussion phase is generally confined to the process of the budget as a whole or any larger principle. The finance minister is the one presenting the budget, and therefore she will have a right of reply to the general discussion. And once the general discussion is over, then the vote on account is generally passed. That till the time the final budget is passed. That's generally how the budget is done. Now, what happens is demand for grants, as I told you before, are the closest to the money bill. Within the demand for grants, you will have made and charged expenditures. Charged expenditures are not voted, but made expenditures are voted. So the Lok Sabha will pass it, send it to the Rajya Sabha. The Rajya Sabha will discuss. The Rajya Sabha will also symbolically vote on the budget, give it back, and then will be sent to the president for assent. Now, if the budget fails, that means the Council of Ministers' primary job to run the affairs of the country, the way they want to spend their financial resources, that is being questioned. Which is why, if the budget fails, then the Council of Ministers have to necessarily resign. Now, under ordinary circumstances, where the houses have equal powers, there could be the case of a joint sitting. Now, there's also a joint sitting for something called a motion of thanks and also something called a general address. A general address is a separate article, and a motion of thanks is a separate article. See, a general address is when the president or the governor, whenever they want to, can address a joint sitting. At the central level, this has never happened before. Now, a motion of thanks is this is important. The motion of thanks is the first sitting of the first session of the year and the first sitting of the first session of the new Lok Sabha. The president will come and read out the policy statement of the government. Now, in 2024, you're going to have two motions of thanks. One you already had in February, the other you will have end of June, beginning of July. Now, the motion of thanks also has to be voted upon. So after the joint sitting, the houses will go sit separately and the Lok Sabha will vote, and then the Rajya Sabha will symbolically vote. If the motion of thanks fails in the Lok Sabha, that means there's a policy disconnect. And because there is a policy disconnect, the Council of Ministers will have to effectively resign. This is generally how it works. But the ordinary reasons for joint sittings is effectively a deadlock. Now, a deadlock happens when either of the two houses have effectively rejected a bill, or there are disagreements over certain amendments, or 6 months have passed and no action has been taken. Then the president can call for a joint sitting, but it is not necessary. And the president will do so obviously on the advice of the Council of Ministers. The two things you cannot have joint sittings for. One is a money bill because the Lok Sabha has more powers, and constitutional amendment bills because it will undermine the powers of Article 368 and it will give an unnecessary edge to the Lok Sabha. And you don't have the concept of joint sittings at the states because at the states, the legislative assemblies are effectively overriding the councils. The interesting thing is you do not have a joint sitting for a constitutional amendment because a constitutional amendment under Article 368 anyways has some federal impact. If not, will have a national impact on the most important law. So you would want the houses to sit and vote separately. This is the general passage procedure as far as our legislatures are concerned. And then finally, parliamentary committees. Parliamentary committees have to be first understood in the context. You'll have similar setups at the level of the states as well. Generally, you first need to understand the basic notion of it, the composition, the creation, and the method of the creation. It is all dependent from house to house, which is why things like these are not particularly asked a lot as far as the exam is concerned. So parliamentary committees can have members of both houses, can have separate committees for either house, can also be for one single house. At the central level, you will generally see that if there is a single house committee, which means the other house cannot have it, then it is generally a Lok Sabha house. And all parliamentary committees largely function under the supervision of the Speaker as the presiding officer of the Lok Sabha, also reflective of center stronger than the states. Now, these parliamentary committees could be created by Lok Sabha resolution rules, by Rajya Sabha rules, sometimes an act of the parliament, sometimes by a motion or a resolution, or sometimes by the inherent powers of the presiding officer. Now, sometimes the members could be elected, sometimes they could be nominated by the speaker, and generally they are reconstituted every 1 year, every 5 years, or once there is a dissolution. And ministers generally cannot be members of the parliamentary committees. Now, broadly speaking, there are two kinds of parliamentary committees. One, these are standing committees. That means they will always exist. Their members will keep changing every 1 year, 2 years, 5 years, etc., whatever, but they will always be there. And you have ad hoc committees which are created for a specific issue or a specific law. For example, you can have an ad hoc committee to discuss demonetization, maybe. Or let us say there is a bill which has been introduced in the Lok Sabha or the Rajya Sabha, and both houses have to equally pass it. So you can have a joint committee created only for the purposes of that bill. Or you can have a separate committee of the Lok Sabha and the Rajya Sabha only for the bill. Once the bill is done, the committee is lapsed. So that's generally what is called an ad hoc committee. What is important for the exam, though we've not seen questions from here in the last 2-3 years, is what is called standing committees. So standing committees can sometimes be appointed, can then be elected. That's okay. There are generally three kinds. First, because finance is so important and financial scrutiny is so important, you've got financial committees. Then you have departmentally related standing committees which are attached to different departments in a ministry. And then you have other purpose-driven committees. So let's start with the Public Accounts Committee. The Public Accounts Committee, and this is where the interesting part is. Remember, I told you Lok Sabha is twice the size of the Rajya Sabha. So in any committee which will have both Lok Sabha and Rajya Sabha members, roughly Lok Sabha members will be twice that of the Rajya Sabha. This is a very easy way to know if your questions are getting right or wrong. Now, a Public Accounts Committee, very simply, is a committee which is an elected committee. And this committee has a total of 22 members. 15 of them comes from the Lok Sabha and 7 of them comes from the Rajya Sabha. Though this is not important, but the duration of this committee is just about 1 year. The chairperson is appointed, the members are elected, and it is also given support by the Lok Sabha Secretariat. Each committee will have either the Lok Sabha or the Rajya Sabha Secretariat giving you some form of support. Now, in fact, it is a primary Lok Sabha committee, which simply means that even if the Rajya Sabha members are not there, the committee can still function. It's not compulsory to have Rajya Sabha members. If there are Rajya Sabha members, then of course you can have equal voting for each of the members. Now, how do you elect the members of the Public Accounts Committee? It's proportional representation through single transferable vote in the Lok Sabha. But such a process is actually not required for the Rajya Sabha. Now, the Public Accounts Committee does a very important job. It does three things. It will examine appropriation accounts, annual financial statements, and any other report. So the Public Accounts Committee would look at the appropriation accounts, second, the annual financial statements, and third, any other reports. Now, as far as the appropriation accounts is concerned, you will look at, say, CAG reports, you will look at public financial reports, civil ministers, railway ministers, defense services, postal services. And that is how your appropriation is looked at. How are you effectively spending your money? Which is why the reports prepared by the CAG, who does a very expert evaluation of how the money has been spent for the right reasons or not. The CAG's reports are tabled before the Public Accounts Committee. Then you have the Committee on Public Undertaking. Now, the Committee on Public Undertaking again has a total of 22 members, out of which 15 comes from the Lok Sabha and 7 comes from the Rajya Sabha. Now, again, it's not compulsory specifically for you to have Rajya Sabha members, but if you do, great. The duration of this committee also is 1 year, because if the budget is a year and financial allocation is on a yearly basis, then public accounts and committee and public undertakings will also be reconstituted on a yearly basis. What they primarily do is they look at the performances, a comprehensive audit, a comprehensive evaluation, an audit, and even a horizontal evaluation of public sector undertakings. Now, what is the meaning of these? I can explain to you, but it's not really important for the prelims exam. An audit is a financial scrutiny of accounts. A comprehensive would be, let's say, this year's public sector undertakings committee was looking into the comprehensive evaluation of the Bharat Heavy Electricals Limited. And horizontal would be you would look at a specific sector and generally see how are things run. That's effectively what is called Committee on Public Undertakings. Then you have the Estimates Committee. Now, the Estimates Committee, again, because you're looking at financial estimates, will have 30 members, and each of those 30 members will only and only come from the Lok Sabha. Because here you are helping the ministries or the department with the estimates that they think that they will require, or they will suggest alternative policy. So you're effectively playing a pre-money bill role. So the Rajya Sabha cannot be participating because of center stronger than the states. Here also the ministers cannot be a member of the estimates committee. Now, after that, you have departmentally related standing committees. In total, if I remember correctly, we've got about 24 departmentally standing related committees, and each committee has 31 members, and 21 come from the Lok Sabha and 10 come from the Rajya Sabha. You will see the same 2:1 ratio here, here, and here. If there are people from both, Lok Sabha will generally be twice than the Rajya Sabha. And out of these 24, 8 committees are supported by the Rajya Sabha Secretariat, 16 committees are supported by the Lok Sabha Secretariat. Now, what do departmentally related standing committees do? They will examine demand for grants, as I was telling you, so that the ministries can make a better outcome. This is also symbolically to ensure there is called parliamentary democracy and upholding the mandate of the lower house and checks and balances. Because otherwise the budget passage is a formality. The majority will pass it in a second. It can also examine bills that are referred to it apart from the ad hoc committees. It can also examine annual reports of different ministries. It can also look at long-term policy documents. So it is truly one of the most profound committees that we have. What DRCs do not do is that they do not get into suggesting cut motions in the budget that, oh, we need to reduce money here. They do not get into a day-to-day administration of it. They do not get into other areas of parliamentary committees. They do not get into reviews of public sector undertakings. And generally what happens is the ministers every 6 months have to give a status of exactly what these committees are doing. Now, apart from this, you will have what is called other standing committees or committees by purpose. Now, if you see, there's a very delicate balance. You will see committees separately for Lok Sabha and Rajya Sabha for intra-separation of powers. You will see committees of both Lok Sabha and Rajya Sabha members together. This would be for collective parliamentary democracy, things which are common, and things which are larger than the independence of the House. And then you will also see something called a committee only for the Lok Sabha or the Rajya Sabha. Now, only Rajya Sabha does not happen, but only Lok Sabha absolutely happens. This will be for center stronger than the states. So, for example, you have the petitions committee, separate houses for Lok Sabha and Rajya Sabha. Now, generally what will happen is Lok Sabha members are going to be 15, Rajya Sabha members are going to be 10. So what will basically happen here is that you will have 15 members in the Lok Sabha committee on petitions, and you will have 10 members in the Rajya Sabha committee on petitions. Now, these are essentially to examine bills, public interest, matters of the union list, suggest ways of action for the House. These are generally nominated committees, and until the time they're reconstituted, they generally remain in holding the office. Then you have the privileges committee that I was talking to you about. Again, the same thing, 15 members from the Lok Sabha, 15 from the Rajya Sabha, 10 from the Rajya Sabha. They look at questions of privilege as determined by the presiding officer. We also spoke about government assurances. This is where the mandate of the committee doesn't get lost after a dissolution. They basically track what are called ministerial assurances that are given on the floor of the House. Same 15 members in the Lok Sabha Committee on Assurances, 10 on the Rajya Sabha. Why? Because each House will have their own privileges, their own petitions, their own government assurances, their own issues of subordinate legislation, which is delegated legislation. Sometimes the law will empower the ministry to make certain rules, and the ministries have to make those rules within an amount of time. If they don't, then these committees can therefore ask them about the status of it, which is why this committee on subordinate legislation is important, and in fact has been asked in the previous years also. The Committee on Subordinate Legislation will keep checking that if you have a 6 month deadline to make rules to a certain law, why have you not done it? Right? Similarly, you will have a papers laid committee, which is essentially to examine the different papers, researches that are laid on the floor of the houses. You will again have 15 members for the Lok Sabha committee, 10 members for the Rajya Sabha committee. Similarly, each house will have their own business advisory committee. So separate again 15 and 10 to advise on, of course, how much time should be allocated to whom. Generally, the business advisory committees are headed by the presiding officers only. Now comes the interesting part, which is private member bill committees. Now, generally what happens is that a private member bill is more openly discussed in the Rajya Sabha because you have no concept of a political majority, but a political loyalty. But in the Lok Sabha, it is a severe question to the impact of the Council of Ministers' confidence. So you have a dedicated committee in the Lok Sabha comprising of 15 members who will look at private member bills. And therefore, it is an important committee. In the Rajya Sabha, this is done largely by the Business Advisory Committee of the Rajya Sabha. Now, the Rules Committee will examine the rules of procedure, will try and figure out if there are any problems, give suggestions, interpretations. Each house has their own rules, and because each house has their own rules, it becomes a very, very interesting committee to examine the outcome of these. And very, very interestingly, Rules Committee is the only committee where the number of Lok Sabha members are 15 and the number of Rajya Sabha members are 16. Separate committees, but yes. And then you have something called absence of members committee. Now, the Rajya Sabha itself decides on a house-to-house basis, but the Lok Sabha has a dedicated committee who basically looks at why has a member been absent for such a long time, examine the reasons of it, has about 15 members, but only and only in the Lok Sabha. Then you have the General Purposes Committee, which basically advises the presiding officer on things that do not fall under any other committee. You'll have a separate committee for the Lok Sabha and a separate committee for the Rajya Sabha. Though the numbers can change, but generally it comprises of the presiding officer, the panel, and senior leaders of all political parties. Then you have a House committee, which effectively looks at, say, the recommendation of residential accommodation, separate again for Lok Sabha and Rajya Sabha. Then comes committees, which will have a very dedicated purpose. For example, you have a salaries committee to examine whether the salaries are adequate or not. But this committee is no longer functional right now. Again, you have members of the Lok Sabha and the Rajya Sabha. You have an Office of Profit committee because Office of Profit is a larger issue of disqualification. So you'll have 10 members from the Lok Sabha and 5 members from the Rajya Sabha determining, basically giving a recommendation on whether an office of profit was violated or not, or how can we better make the laws on it. And it generally has a decent functionality to it. Because we have a common library to the parliament, we have a joint committee, which is 6 Lok Sabha members and 5 Rajya Sabha members. And because Office of Profit is also common, so these are one single committee comprising of Lok Sabha and Rajya Sabha members both. And then because welfare is universal, you have a SC/ST committee, an SC/ST committee, parliamentary committee, and a women parliamentary committee. Again, we'll have 20 members from the Lok Sabha and 10 from the Rajya Sabha, essentially looking at what are the different welfare processes that have happened, what are the different measures, what can we do better, and so on and so forth. So generally, this is how it works. You also have a subcommittee on OBCs, but that is not entirely functional all the time. But this is more than enough. If you know the purpose, you never need to know the members, and that's pretty much it. So the highest number of members are always and always in the departmentally related standing committees. After that, you have estimates committee with 30 members. So this is how your entire lecture number 6 is. What I've particularly done is that I have changed the format in a way so that you can see what is in front of you, because prelims requires a hyper focused mode, and this should effectively take care of any question really that the exam can ask you. I have purposely not done MP lads because MP lads to be asked in an election year is extremely unlikely. So this should be enough to handle the larger questions that the prelims exam in 2024 can ask from union or state legislatures. Thank you. See you for executive in lecture number 7.